Good morning, everybody. Thank you all for joining us. We've got a couple folks that are, oh, there they go. We are all in from the waiting room. Well, thank you so much for joining us here today. We're happy to have you with us, and happy October. Happy Halloween, as my daughter said to me this morning. We're going to start like we usually do with some Zoom housekeeping tips, including the request that you stay muted while we're doing our Q&A today. Of course, you're welcome to unmute yourself to ask a question verbally if you would like to do that, but if you could otherwise stay muted just to keep background noise to a minimum, that would be great. For those that are newer to Zoom, I feel like at some point I'm going to have to stop saying that because none of us are newer to Zoom anymore, but your Zoom toolbar might be at the bottom of your screen. That's where you're going to find your mute button, your unmute button, as well as your start and stop video button. You'll also see the chat button there. The chat is the best way to ask questions while we're talking during today's Q&A. And I do want to let you all know that we were a little bit light on questions today in terms of those that were submitted in advance. And so if you have a question that you maybe have been on the fence about asking, today would be a good day to put it into the chat. In particular, we're going to focus on and prioritize any questions that are related to budgets and the budget process, since we are firmly in the thick of that season right now. And I also put a message into the chat that tells you how to submit questions for each week going forward, as well as links you to our YouTube channel, where we post all of the videos from previous Q&As. Some of you might have noticed that I haven't posted the videos for the last 2 weeks, and so I did just get those posted right before we started today. So keep that in mind if you ever need to go back through the archives to look at what we've said on a certain topic. Sometimes when we get so we do get a lot of questions kind of over and over again, and so we will often refer you to the YouTube channel to previous videos rather than covering the same content many times. Also on the topic of budgets, we did do a budget primer, a full hour-long session where all we talked about was the budget ratification process. And so if you go to the YouTube channel and look back, I think it was about 1.5 years ago, maybe, you should be able to find that as well. And because the statute, or at least that portion of the statute, hasn't changed since then, the process is the same as well. Some of you may wonder why the heck we're still talking about budget ratification, because this statute has now been in effect for over 6 years. And we'll get into this a little bit more once I dive into the subject, but the reason essentially is that we are still seeing clients doing it wrong. Not to put too fine a point on it, even though the budget ratification process has been in place, given the statutory change since July of 2018, a lot of associations are either unaware of it or seem confused by the process. And so we want to keep covering it until we see those mistakes lessen over time. So back to our sort of announcement section. We have been also reminding everybody that, and we do this every week, we are not here to give legal advice. We're here to talk about general legal information that we think is useful to a broad cross-section of community associations in Washington State. So if you email us with a very specific question that either asks us to interpret your particular governing documents or a specific situation that you're dealing with, we're probably not going to be able to answer that question. We might try to cover the topic generally when we think that it's, broadly applicable or helpful to people. But otherwise, just please keep in mind, this is not legal advice. We can't do that in this forum. The only person who can give you legal advice is your association attorney. And if you don't have one, you should get one now before you need one. That's a soapbox that I get on often, and so I'll just leave it at that for now. We have also been reminding everybody for a while now that the Corporate Transparency Act is still currently set to take effect, the reporting requirements, on, I think it's December 31st of this year, actually, is the deadline. And a lot of our clients have been asking us, should they comply? When should they comply? Could we do the CTA filing for them? What does this all look like? And we're going to talk more in detail about the CTA during the Q&A itself. But we wanted to sort of remind folks what we've been saying, which is that CAI is challenging the applicability of the CTA to homeowners associations and condo associations nationally on a couple of different fronts. And the hope is that they will either be successful in delaying the implementation date, or exempting community associations from the reporting requirements of the CTA. So we do have plenty of clients that are continuing to sort of hold out hope that that will happen and are delaying compliance with the CTA for at least a few more weeks now. And we don't think that that's unreasonable, in particular because the process is not long and complicated. We do want to note that I know there's several law firms out there and also several management companies that are offering to report for community associations, some of which are attaching significant fees to that. We think that boards can complete the report themselves, and the process, which I know it's daunting because it's new and so nobody knows what it looks like and people feel intimidated by that, which I completely understand. But it's not a complex process and it does not require a lawyer or any particular training to comply with. So again, we'll talk more about some details later, but I think if you're continuing to hold off and hoping that CAI comes through in terms of delaying or exempting community associations, that continues to be a reasonable option. You know, we might start changing our tune on that towards the end of this month, I think, because we don't want to leave things until the very 11th hour if we do have to tell clients to comply. So just keep that in mind. And our last announcement / reminder is that CA Day is coming up. It's on Saturday. So we've been talking about it for like 6 weeks now, and it's in a few days. So number one, we hope to see a whole bunch of you there. We are going to have a booth. If you are there, please come say hi, introduce yourselves. Most of our attorneys will be there most of the day, and Chelsea will also be corralling all of us. So we look forward to seeing you there. Ken and Katie are going to be doing a presentation on what you can, should, shouldn't, must, etc. do when Wakaiowa is your governing statute. And I'm also going to be doing a presentation with our WSCAI lobbyist, Christelle Perkey, as well as the chairwoman of our Legislative Action Committee, Hillary Bublitz, about a 2024 legislative session update, essentially. So we hope to see many of you guys there on Saturday. And without further ado, unless Katie, did you have anything you want to add before? No? Okay, I'm going to just jump into the budget topic. And again, I'll remind everybody that if you have questions, either about budgets or about other things, please put them into the chat. We are likely to have time to get to those questions. So the reason that we wanted to talk about budgets today is because we're 3 months from the beginning of a new year. It's now less than 3 months until the new year. And most of our clients, not all of them, but most of them, want to raise the dues on January 1st. And if you want to raise the dues on January 1st in a way that's enforceable, you need to be planning your budget now, and you have to schedule a budget ratification meeting before the end of the year. And what I mean by that is we do have some clients who will raise the dues on January 1st, but their budget ratification meeting isn't until January 15th. You can't raise the dues before you actually ratify the budget. And you certainly can't later refer an account to your association attorney to collect unpaid assessments and expect them to collect the increased amount before the ratification took place. And I think what I'll do is sort of back up and say, here's like the 30,000 foot view. The thing that we tell our clients over and over again, and that you all have heard us say here many times, is that procedure matters. Procedure over substance is the single biggest point of vulnerability when it comes to owners successfully challenging things that an association has done. In other words, when owners are successful in challenging association actions, it's usually because the association messed up how they did the thing versus the actual thing itself. So you can't hold a meeting in January and backdate the increase to January 1st. There is a way to handle that. So if you know you're not going to be able to have your budget ratification meeting until January 15th, you have to disclose how you are going to handle the difference between the enforceable amount of the January dues and the amount you want to be able to collect for January. Maybe that looks like a little extra charge in February or whatever, but that does have to be disclosed in the budget ratification paperwork in order for it to be enforceable. I want to remind everybody, the budget ratification statute that everybody in Washington is bound by is in Wakaiowa. It's one of only a couple sections that apply to everybody. It's RCW 6490-525. And I see Katie just put that into the chat. you have to follow the specific requirements from that statute in order to properly ratify your budget. And the statute itself is literally a checklist. In other words, if you look at the list of things you have to disclose on that's listed in the statute, and then you look at your documents and your documents don't have everything on the list, then you're not ratifying your budget correctly, right? So in that list in 525, it includes that you have to state how much each unit has to pay and when. So this is actually one of the things we see overlooked the most often. And I think it's because for a condo association, for example, it seems obvious. We're raising the dues effective January 1st, and they're due on January 1st and the 1st of every month after that. But the statute does require that you actually say that. So somewhere it should say this budget will take effect on January 1st, and the increased assessments will be due on the 1st of each month thereafter, something like that. It doesn't have to be anything fancy in terms of the language. You have to state the recommended reserve contribution and the proposed actual reserve contribution. You have to state the deficit or surplus, which I think is very funny that it even mentions a surplus, because not the vast majority of associations do not have a surplus in reserve funding. But you have to state the deficit or surplus in your reserve funds for all units specifically. And what this means is, in an HOA where every percentage allocation is equal for all of the lots, then your average reserve deficit is compliant with the statute. But in a condo association where your percentage allocations vary by unit, you have to actually take the total reserve fund deficit, multiply it by the percentage allocation for each unit, and then disclose those specific deficit amounts by percentage in order to comply with the statute. This is another one of the most common mistakes that we see. And I think it's because for a long time, for a number of years after Wakaiowa was implemented and this particular budget section became effective for everybody, the reserve study summary sheets that a lot of reserve study companies were producing just had an average. It didn't have the per unit deficiency. And the obligation for an association to disclose the per unit deficiency is a statutory obligation that exists regardless of whether your reserve study actually gives you that information in the summary sheet. So if they don't give it to you to make it easy for you to disclose it to your owners, then you have to put it into a spreadsheet and create that disclosure so that you can comply with the statute, right? You also have to state how much is in your reserve account and the percentage funded your reserve account is. You have to give 14 days notice of a budget ratification meeting, and you have to actually hold a meeting. We've had clients ask us before if they could ratify the budget by mail, and the answer is no. You cannot. The statute requires a meeting. I think, so on the one hand, of course, you have to comply with and disclose everything that's on the checklist, essentially, that's created by the statute. The flip side of that is you don't have to do more than is required by the statute. We know that sometimes we see clients trying to comply both with, for example, the Condominium Act and Wakaiowa in terms of the language around budget ratifications. And that is not necessary. You don't have to comply with anything other than the statute. You don't have to do more than what is required by the statute. So what does it mean if you failed to follow the process correctly? It means that you have an unenforceable budget for this current year. It does not mean that you have no budget. It just means you would have to fall back on last year's budget until you properly ratify or fix your ratification process. As a practical matter, if an owner doesn't challenge your process, that might not mean much to your association. The problem comes in when either an owner challenges, say, the increase in the assessments, or you send an account to your association attorney for collection, and they have to tell you that you failed to ratify your budget correctly, so I can't collect the 2024 dues amount. I have to use the 2023 dues amount because your ratification process was not adequate, didn't comply with the statute. So, you know, I think I started to say earlier today, part of why we are continuing to cover the budget ratification process and to flesh that out a little further. for those of you who are very familiar with this process and really sick of hearing us talk about it, we are equally sick of talking about it. But until we start to see fewer mistakes in the accounts that come to us for collections, which is where we get to see these errors most often, we just want to make sure that we're continuing to put the information out there, continuing to answer people's questions about it, so that we have a clearly defined budget ratification process. So again, it's RCW 6490-525. Treat it like a checklist. Oh, the other thing is, if you're a client that's had a few budget ratifications and you're so sick of your attorney telling you that you're doing it wrong, have your attorney review the budget ratification packet before you send it out to your ownership. That is the single easiest way to make sure that you are complying with the statute, and to make sure you don't have that attorney come back to you later to say you did it wrong, is to have them tell you in advance the packet is adequate or the packet misses something and what you need to do to fix it. I don't see any, let's see if there are any budget questions in the chat. I don't see any budget questions in the chat right now. So Katie, did you want to add anything before we move on to our other topics?
Not necessarily add, but more emphasize. I just have two things. One, why we're talking about this now is so you don't wait. And Valerie was talking about it at the beginning of, if you want your dues increases to start January 1st, you need to do it sooner. Not only that, but like say that 14-day notice requirement is really important. So if you sent your notice on December 20th, you would not be able to collect increased dues on January 1st, because that does not comply with the 14 days notice. So basically, if you want to start January 1st with increased dues, start planning now. The other thing to emphasize is that you need to have the meeting, but that doesn't mean anyone needs to show up. The budget is ratified unless it is rejected by a majority of the owners. So if no one shows up, the budget's ratified and you had your meeting. So that's just important to keep in mind.
No, that's great to emphasize. And I want to also add, the statute specifically says that it doesn't matter if you make quorum at the ratification meeting. And this is one of the reasons why a lot of our clients are choosing now to split their ratification meeting from their annual meeting. Because for an annual meeting, quorum matters. For a budget ratification meeting, it does not. The other thing I want to remind everybody is, when you have your budget ratification meeting, you don't call for a vote to approve the budget, because the default is that the budget is going to be approved. So you open the meeting, you ask if the owners have any questions about the budget. And the question then would be, does anybody vote to reject the budget? And only if more than 50% of the voting power in the community votes to reject the budget is it then rejected. Otherwise, it's ratified. So related to that, we also have a lot of clients that sometimes ask us the question of, like, should we send out ballots, absentee ballots, or, proxy forms or whatever with the notice of the budget ratification meeting? I will offer that I don't think it's necessary. Certainly, there's no requirement that you do that. And one of the things that you do by including those documents, again, as this is assuming it's just a ratification meeting, there's no other votes taking place, is you are making it a little bit easier for your owners to vote against the budget. So if you don't include a ballot and you don't include a proxy, and you do hold a ratification meeting that requires people to attend in order to vote, they have to take the affirmative step of attending the meeting in order to try to vote the budget down. And so that is, one reason perhaps not to include a ballot or a proxy form with the notice of the budget ratification meeting. I think that's it for that topic for now, Katie, unless you want to say anything else before you jump into the next subject.
Nope, I think it's time to talk about CTA. So our first question, we had two questions come in on the CTA. So if there are more questions, put them in the chat, but we'll just get started. When filing a BOR, which is the beneficial owner, I forget what the rest of the acronym is, but basically it's what the board members have to list as. When filing a BOR, who is the correct person to list as the beneficial owner for the association? Do we ask the board to nominate a member? If no one volunteers, what's the next course of action? Would we, the management company, be the ones listed as the recording agency? Or should that be the president or board member? And then we'll get into penalties in a second. I'm going to break these up. So as Valerie mentioned, just as to get things going, this is still being challenged by national CIA, and there's lobbying in Congress still ongoing. So we don't know the exact status yet. And thanks, Pat. A beneficial ownership, BOIR, is beneficial ownership information form. Basically, because community associations were not the intended audience for this CTA, the Corporate Transparency Act, a lot of things are confusing when they apply to community associations. So in a normal corporation or LLC, the beneficial owner is the member of the LLC, is the shareholder in a corporation. Obviously, that's not the case for community associations. So the guidance that National CAI and WSCAI has said is that the beneficial owner is the board member, the current board members, all of them. You can't list all the owners, which would technically be the ones who like benefit from it. So the people who need to fill out the BOIR is every current board member. It's reasonable to be at least the board president, but it should be every board member needs to be listed. And if the board member changes, you need to update the form. If someone doesn't want to be listed because the government is asking for specific information that someone may not want to provide, they should consider stepping down as a board member, because it is a requirement that the board members be listed as the beneficial owners. So if they're not willing to comply with the statute, that is something that maybe they're not fit to serve as a board member. In terms of who is the one who can report all this, specifically is, would we, the management company, be the ones listed as the reporting agency? If you are the entity submitting this form on behalf of the association, meaning the reporting agency, you have to list yourself. So basically there are two things that need to be submitted. You have the beneficial owner information form, which has all the board member information. And then the reporting agency also has to give a certain amount of information. The reporting agency can also get the FinCEN number so that it's easier to fill out. But whoever is submitting the information on behalf of the board is the reporting agency. That could be a specific board member. It could be another business, a management company, a CPA, a lawyer. Whoever is reporting it is the one who fills it out. Just like when you're doing a Secretary of State filing. So the next part of the question is, if an association does not file, what are the penalties? And can you please clarify in what instance an association would qualify for a filing exemption besides 501c4 status? So first, other than a 501c4 status, which does not apply to virtually all associations, there are no exceptions or exemptions at this time. The IRS has made it very clear that virtually all condos and HOAs are not exempt at this time. So that means if you don't comply, you could be, the association and the board members could be subject to civil and criminal penalties. And what I'm going to give is a maximum. And so it could be smaller, again, because associations are not the target of the law. But the civil penalties are, you could be fined up to $500 per day for this violation for as long as it continues. And the criminal penalties are a prison term of up to 2 years and or a fine of $10,000. So again, you're not the target of the law, so they could be lower, but you should be aware of what the penalties are. Our recommendation is that if the law is not successfully challenged in the court or changed by Congress, that your association comply. My note says before or by December 31st, but that's like the absolute deadline to comply. So like I mentioned with the budgets, don't wait till December 20th. Like, you don't want to do this over Christmas. Think about it before the holidays. Valerie, do you have anything to add for that one?
Yeah, I want to add a couple of things. I want to remind everybody. So first of all, I put a link to a recent blog article that I wrote in the chat. And one of the things that we say in the blog article is something that we've said in our Q&As in the past, which is The single biggest reason board members seem to be concerned about this reporting requirement is because they don't want to hand over their personal identifiable information to the association, to the management company, whatever. The way to avoid that is for each individual board member to take the 10 minutes to go to the FinCEN website themselves, sign up for their own FinCEN ID number, and then just provide that ID number to the person who is filing the CTA report for the association. In that way, you are just giving the government a copy of your ID, which, spoiler alert, they're the ones that issued it, so they've already got all your information anyways. You're not giving the government any information it does not already have. But all you have to give to your association is that individual FinCEN ID number, which the association then uses to fill out its own CTA report. So that is a way to get around what seems to me to be the primary concern that we're hearing from board members about the CTA reporting requirements. The other thing that I want to emphasize that Katie already said, but it bears repeating, nearly every single community association is subject to the CTA reporting requirement and does not qualify for the exemption that was mentioned in this question. The only types of associations that might qualify for the exemptions, I mean, there's exemptions like if your annual budget is $5 million or larger, you know, those types of exemptions exist, but the vast majority of associations don't have budgets that are that large, right? The only other potential way that you might qualify for an exemption is if you are a community association that actually is essentially open to the public, right? So that's also not true for virtually every community association. There are some associations, few of them, but there are some where they are so large that, for example, the parks within the community really are a public accommodation because they aren't limited to just the owners within the community. And if you're a 501c4 community that does provide significant public accommodations to people who are not members of your private association, it's possible that you could be exempt. You would need to consult with your association attorney to verify that. But I just want to emphasize that everybody's out there like looking for loopholes and we're a nonprofit. So do we really? Yes, you're subject to the CTA. Almost certainly you're subject to the CTA. But the whole thing with each board member getting their own FinCEN ID number and then just giving that ID number to the association for its own CTA report, it cuts out half the work in filing the CTA report to begin with, number one. Number two, it takes 10, 15 minutes max for you as a board member to sit down at the computer and get your own FinCEN ID number. And number three, it eliminates the necessity for you to do things like make a copy of your driver's license and give it to your board, your management company, whoever it is that you don't want to have that information.
Yes. Also, social security number, I think, is required, which is another reason to get a FinCEN. And if you have, I think, TSA pre-check, you're already halfway there, and they can, I think, even take that number and use that as your background check. So that's helpful. Before I move on to the second question about the CTA, there is a clarification in the chat, which is, I believe, if I understand this correctly, that each individual, if any, who directly or indirectly through any contract, agreement, understanding, relationship, or otherwise owns 25% or more due to the voting power to influence business decisions must be on the BOI report as well. Am I correct? So basically, yes. And that's why every board member needs to be on there, is because they're the ones that make the decisions. I think technically if someone owned like 25% of the units, they may need to be included on that. But for the most part, it's just going to be board members who need to be on the BOI. Okay, so the next question is, can board members file the CTA on their own? If so, can they manage the account on their own, such as the annual renewal and or update any changes to the board members? Yes. Complying with the CTA is ultimately the board's responsibility. You can maybe delegate it, probably delegate it to an association manager, an attorney, a CPA, but ultimately, like, the board needs to make sure that it gets done. I know it seems really overwhelming and it is a pain in the butt, but it's not as bad as it could be. So it seems like a really daunting process because it's new, but once you get everyone's FinCEN numbers, it's really just a time-consuming task of putting in a lot of information and a lot of dates, and that's pretty much it. So it's once you get started, it'll be pretty easy to update when you have new board members, to renew every year, and it'll be more administrative, like filing with the Secretary of State your annual renewal. So once we get over this hurdle, if the challenges fail and if Congress doesn't change it, it's going to get easier over time. It's just something you need to be aware of. If you don't have a manager or an attorney or a CPA who will do it, we would recommend picking a board member to do it. We could support the secretary doing it because they're the ones who have to maintain the records, but it could be the board president. You just need to pick someone to do it because only one form is submitted. You don't want everyone submitting their own form. Everyone needs to get their own FinCEN number or provide the information for the beneficial owners, but it's one association submission. Valerie, do you have anything to add?
I would just I think I just want to emphasize what you said, which is it's annoying. It's a pain in the butt. It's going to take a little bit more time the first time you file a CTA report. And then every time you just update it from that point forward, it's going to be much shorter and much easier. And lay people are completely equipped to do this. So I think that, we've had a lot of clients contact us asking us if we'll do it for them. And I just don't see how it makes any sense for you guys to pay somebody else hundreds of dollars to do something that a board member could accomplish in an hour or two at the most, I would think. So, so don't be so intimidated by the process. I don't think it's as bad as everybody thinks it's going to be. But I'm an eternal optimist, so maybe that's part of why I think that. I'm going to move us on to our next question. Is there generic advice to provide for when a board considers whether to allow or disallow garage sales in a condominium style association? Is there generic advice for the overall policy guidelines if they can allow them? And does addressing this need to be in the declaration versus a board adopted policy? The bottom line is that the board gets to decide if it will allow it or not. The board does need to be consistent in its application of this. So if you've got one owner, say you have 3 owners who request the opportunity to conduct a garage sale out of their unit or out of their parking spot or something in the course of a year, if you say yes to one, you should probably say yes to the others unless you have a reasonable basis to respond to those requests differently. Virtually any garage sale in a condo association is going to require the use of the common elements, and the board has the authority to regulate the use of the common elements. So that's why this is something that falls under the board's authority. This does not require an amendment to the declaration. I don't even know necessarily if it requires a policy per se, unless it's something that happens a lot within your community. And in that case, having a policy that just makes it clear to your ownership, is there an application procedure? Are there times of year when these are allowed or not allowed? Is there, I don't know, like a security deposit that has to cover the use of the, the elevators up and down to their unit, whatever the situation might be in your particular association. So I could see a policy being helpful in a scenario where this happens a lot. But again, that is something that's within the board's authority to do, and it does not require like an amendment to your declaration. I think taking into account things like access to the location of the garage sale is important when the board is deciding how to handle, setting up rules around these things. So, is there a gate? Is it a gated community, or can anybody walk in? Is it in the limited common element garage, or is it in a common element parking space, or is it in the unit? What date and what time is somebody proposing to do this? Is it going to require people being given a code to a secured access building or being buzzed into a secured access building? Like, there's so many variables that would be different from one community to the next. So just considering those things as the board determines how to set guidelines for these would be helpful. If you have a policy of what the board will allow, that might make sense, like I said, including things like allowed locations, dates, times, rules about access, etc. we don't see a whole lot of garage sales in apartment style condo buildings. It is more often something that we see in townhouse style condominiums or single family home communities. And I think that we could support a client not wanting to allow garage sales out of individual units within secure buildings because of the security and the access issues. We also have some clients that actually have like garage sale weekends. So we have a client that's actually really close to where I live that has 2 garage sale weekends per year, where everybody in these very large communities knows that a whole bunch of other people are going to be having garage sales at the same time, which makes them more effective for everybody because it's sort of a driver for traffic into the community. And that community also does not allow garage sales throughout the rest of the year. So it sort of contains the traffic and the chaos related to those garage sales to a couple of pre-designated weekends, and then allows the association to limit them otherwise. So I think, I think the generic advice is you have to figure out what makes sense for your particular community based on a whole bunch of factors that I already listed. And whatever policy or set of rules that you consider adopting should be applied uniformly. And as with any new set of rules or policies, it's always a great idea to have your attorney look them over to make sure that they don't run afoul of something else in your other documents or in a statute, and to make sure that you understand the proper procedure for adopting that, as if it is going to be like a formal set of rules that you adopt. Katie, did you have anything you wanted to add to that?
Nope.
Nope.
So
Okay.
the next question is, our HOA's common elements are maintained almost entirely by volunteers. Is there a best practice to follow to protect the community in case of injury, such as asking volunteers to sign waivers? It depends what the volunteers are doing, but a good best practice is to have people sign waivers. We recommend checking with your insurance provider about what they recommend, and to make sure that if a volunteer is injured while working for the association, that the association has coverage for that risk. That would either be, you could have special volunteer language, your general liability policy, but check with your insurance agent. We typically recommend that you have insurance cover injury to volunteers and damage that the volunteers may cause. And it could be, you may not even be thinking about it. Like someone maybe could throw out their back while pulling out a weed, or while mowing the lawn, a rock gets stuck in the lawnmower and breaks a window. Like it's even small things that you're looking for. It's not someone falling off a roof or crashing into a building with a truck. So if you implement a program of waivers and a volunteer refuses to sign it, then don't let them volunteer. Basically make signing the waiver a requirement for volunteering. If they're not willing to sign it, don't let them do the work. Find someone else who's willing to sign the waiver. But yes, have a waiver, check with your insurance. Valerie, anything to add?
No, I mean, I think, yes, the thing to add essentially is that volunteers are great. It's wonderful if you can save the association money that way. But there's a potential cost associated with allowing somebody to volunteer without signing the waiver. And I would rather pay somebody an hourly rate to do the thing than risk the cost associated with a volunteer who doesn't sign a waiver later suing the association because of something, or not even them suing the association, but the association getting sued because of something they did or didn't do. So I'm going to move on to our next question. Under HOPA law, does the board of a HOPA community have the authority to tell a prospective buyer who is under 55 that if they purchase the home, they cannot live in it? Do the covenants or rules need specific verbiage to support that action? So as a reminder, for those who don't know, HOPA refers to the Housing for Older Persons Act. And certain communities, if they follow the rules established by HOPA, are exempt from the restrictions under the FHA that prohibit things like age and familial status discrimination. In other words, the FHA would normally prohibit a community from limiting folks by age who could buy or live within the community. If you follow the HOPA rules, you are exempt from those specific provisions of the FHA so that you can have a housing for older persons community. And the short answer is certainly yes, you can tell them that they are purchasing a unit in a 55 and older community. And you can tell them what threshold you're at, that the 80% 55 and older occupancy requirement of HOPA has been met. We cannot answer the question generically as to whether you can tell them they're not allowed to live in the house if they're not 55, because that question turns on whether the recorded governing documents for the community have other restrictions on age. So here's how it works. Under HOPA, at least 80% of the units or homes must have at least one resident, not owner, but resident, age 55 or older in order for them to qualify for or retain their HOPA status. It is possible 55 or older. Go ahead.
You cut out for a second.
Okay.
We didn't hear after it's possible.
So it is possible to require, if your governing documents, your recorded governing documents provide for this, that 100% of the units need to be occupied by residents age 55 or older. So we can't answer the question of whether your specific board has to tell or can tell a prospective buyer this, because we would have to know the specific contents of your governing documents in order to answer that question. So really the short version of this answer is, I don't know, you got to go ask your association attorney, because the answer depends on what your specific governing documents say. So more generally though, a board should certainly and can certainly notify prospective buyers that this is a 55 and older community. The governing documents and the resale certificate should say that the community is a 55 and older community and should list any other restrictions that exist based on age. We do have some clients where no residents under 55 are allowed, even if there are others in the unit that qualify, meaning we have some clients where everybody who lives there has to be 55 and older, not just one person per unit up to that 80% threshold, right? A HOPA community could choose to allow children or people under the age of 55, as long as, again, one resident in 80% or more of the units is 55 or older. But a HOPA community could also choose, like I said, not to allow anyone under the age of 55 to live there. But creating any new restrictions on age that do not currently exist in your recorded documents would likely require an amendment to the CC&Rs or your condo declaration. Obviously, you can only make that amendment after a vote of the owners, etc. So for your specific answer to this specific question submitter person, you need to contact your association attorney and ask them to answer this particular question for your community. But hopefully that general information is at least helpful to some. All right, excuse me while I take one more sip. I'm getting over a cold and I don't want to cough in everybody's ears. Excuse me. Here is our next question. Besides capping the number of rental units, what can an HOA do to prevent, discourage, or disallow purchases of units by commercial entities using them as income-producing rentals, or whether rented or not, for short-term use by their employees, clients, or associates? The short answer to this question is not much, meaning not much outside of adopting an enforceable rental cap. There is not much that you can do to prevent an LLC from purchasing a unit to be lived in by a member of the LLC. We do think there is some stuff that can be done when we're talking about the occupancy of that unit by employees, guests, invitees. Those can be treated differently than someone who is a member of the LLC with an ownership interest in the company. You can't just blanket prohibit commercial entities from purchasing a unit, but you can always regulate the conduct of any occupant within a unit, as long as the way you regulate that behavior is uniformly applied across the board within the community. So some things you can do are adopt things like quiet hour rules, parking rules, rules around disposal of trash. Things that you can't do are adopt those types of rules that only apply to rental units, right? So if you're trying to regulate behavior, you have to regulate everybody's behavior within the community, not just the behavior of those who live in tenant occupied units. If a person is violating the rules, you can take enforcement action. But again, that enforcement action should be something that you're taking across the board whenever anyone is violating that rule, not just somebody in a LLC owned or tenant occupied unit. If you need to know what you can do in your particular community, I think it goes without saying at this point, because we say it so often, you need to consult with your association attorney to determine what you might be able to do within your community. You can try to amend your declaration to do a number of different things. One thing you could consider is a seasoning provision. That's what they're called within the industry, which is essentially an owner occupancy requirement, requiring that anytime a unit is sold, the owner has to live in it for 1 or 2 years before the unit can later be rented out. This is not favored by the FHA. So if you care about FHA certification within your community, you care about people being able to get FHA guaranteed loans, then you don't want to put a provision like this in your rental amendment because the FHA doesn't like it. But this is specifically targeted to limit the incidence of sort of landlord entities purchasing units within your community. You can also amend your declaration in certain circumstances to prohibit any type of short-term rental. I want to be careful in my statement on that because the existing language in your declaration around the issue of rentals will dictate whether it's actually possible for you to adopt an enforceable restriction on this type of use. And the reason I say that is because there has been case law in Washington state that says 2 things. Number one, short-term rentals are not considered a commercial use in Washington. And number 2, a rental restriction adopted within a community that had no suggestion of the ability to restrict rentals in the original CC&Rs was found unenforceable because there was no notice based on the original language of the potential for that type of future restriction within that community. We see that type of issue most often in single family HOAs. Those are the communities that are going to have the hardest time adopting enforceable rental restrictions. Usually condominiums have an easier time adopting enforceable rental restrictions. But again, you have to consult with your association attorney to know whether and how you can amend your CC&Rs with respect to rentals, short-term usage, commercial ownership entities like the question mentions. So again, I think, going back to the question of how to actually reduce the impact of these types of commercially owned units, one of the suggestions that we have, especially in communities that can't ban or restrict rentals in the ways that we suggested, is to regulate the behavior that creates the problems you're trying to solve. And then, of course, regulate that behavior across the board within the community. Katie, did you have anything to add?
Nope. And we are approaching our last pre-submitted question, and I think we will have time for questions if you want to put them in the chat. So our last question today is regarding the maintenance of archives. Our association has boxes of historical archives, records that go back to its origin in 1989. What are we required to keep and for how long? What kind of records are worth having scanned and retained electronically? So, like we mentioned earlier with the budget statute, there is basically a checklist in every governing statute for what you're required to keep and how long. For new act condos under RCW 6434, which is the only one I put down, it's RCW 6434 372, and you can just Google your governing statute and records and it'll pop up with the whole list. But I will go through some of the major ones right now. So for the most part, and not for the most part, but you have to keep all meeting minutes. That means board, budget, and association meeting minutes forever. That is, off the top of my head, the only thing I think you have to keep forever. So meeting minutes, you can't get rid of. Financial and so like tax returns, budgets, stuff like that. Information used to find violations, information used to approve ACC requests, all those must be kept for 7 years. So if you have a budget, not the minutes, but the budget from 1989, you do not need to keep it anymore. You need to have a copy of the most recent insurance policy and a list of current owners and the annual report delivered to the Secretary of State. So you don't need to keep, last year's annual report for the Secretary of State. You could decide that you want to, but you're not required under statute to keep it. And not required by statute, but something to keep in mind is you can consider keeping any records that show how the building or buildings are constructed, what modifications were made, even if they're older than 7 years. That just may be helpful down the road, but it's not a requirement. And all of these records, whether you choose to keep them and you don't have to, or you're required to keep them, can be stored electronically. Everything can be digitized, and they have the same effectiveness as if they were the original hard copy. That being said, if you have a financial record that you only need to keep for 1 more month before you hit that 7-year requirement and you can dispose of it, you don't need to scan it. You can just hold on to the paper copy for the 7 years and get rid of it after. It just saves you an extra step. You could digitize it, up to you. Most modern copiers have an auto feed scanning function that will make them easy into a PDF. Your management company or your attorney may be a place that has one of these big scanners that you might be able to ask if you could borrow. We've had clients ask us to sort through their many boxes of records and scan them and tell them what they were required to save and what they can shred. If you use the checklist, you can save money doing that and just save your questions for your attorney because it can get expensive, because we had another client with 200 boxes and that just, it can add up. I just did 12 and I felt like it was the most time-consuming thing I've ever done, and it wasn't. But anyway, use your checklist. If there are any questions, ask your attorney. The statute's pretty good about what you need to keep, what you don't. Valerie, anything to add?
Nope. I love the reminder that you can use the statute as a checklist. So I think that's a great place to start. So we did have a couple questions submitted in the chat. I'm going to read the first one. When a board member resigns mid-year, does an amended annual report need to be filed with the Secretary of State, or can the update wait until the next annual report? I'm going to take a stab at this and then Katie can add any questions. And actually, this question is reminding me of something I wanted to say about the CTA. So I'm going to start there. Once you file your CTA report, if there is a change in your beneficial owner information, so if a board member sells their unit or you have an election and there's turnover in the board, you have 30 days to update your CTA report to reflect the current accurate beneficial owner information for the CTA. So keep that in mind. At the federal level, once you start your CTA compliance, there is an obligation to update within 30 days. And since you have to do that at the federal level anyways, my suggestion would be to then update the Secretary of State as well. It costs $10 to file the report to change your board member information. And even if it may not be legally required, which I don't think it is, there are certain scenarios in which having an accurate list of the current board members via the Secretary of State is going to matter, including things like bank account access. We have had clients in the past where there has been board turnover, and in one instance, a board member, I think the treasurer even died, and they didn't update the Secretary of State information. And it created a huge issue requiring them to get a court order so that they could access their own bank accounts, because the bank was relying on the Secretary of State information, which couldn't be updated for whatever reason. So all of that being said, it's $10. It takes like 5 minutes. I would suggest doing it at the same time as you're doing the CTA update anyways, because there are reasons that it is helpful to have that accurate information. I don't know, Katie, if you have anything you want to add to that.
I would also add that sometimes we look at who is a board member with the Secretary of State to make sure that we can actually talk to a board member. And so say the person who stepped down from the board is a nefarious actor and like calling and trying to get stuff done, and we look there. I mean, there's other stuff, but basically it makes it easier for people to know who they can talk to and can't talk to if you have the accurate information.
Yeah. And again, it's cheap and it's so fast. So why wouldn't you, I guess, is the question. The next question from the chat is, can we review the change in the voting/ballot process, and has it gone into effect? And so I think this is not a question that we have the time or the ability to actually answer effectively, because we only have 5 minutes left and we need to look at the changes to the statutes as well. But here's where I'll start on this one. For any community, in order to determine how you handle voting, because there are some differences now that there have been changes to Kiowa, you have to Google the statute. So if it's Condo Act RCW 6434 and then the word voting, and then it will take you to the voting section of the applicable statute. And that is what you need to follow when determining how to handle voting and balloting for each particular community that you work with. So if it's a Kiowa community, that's where some of the changes have taken place. You're going to Google RCW 6490 and the word voting and go to the voting section of Kiowa to look at that. I don't know if you have stuff that you want to say on this one off the top of your head, Katie, or not.
I was going to say a precursor, because we're probably adding this to next week's list of questions, is for you Kiowa communities, there is a secret ballot requirement that is new. It'll apply to everyone in 2028, but for you Kiowa communities, again, secret ballots are now required. And so that, I think, is the biggest change that came out of for the ballot process.
Yeah. The one other thing that I know off the top of my head is the new statute for Kiowa does require the board to verify the validity of proxies. And it doesn't really explain how you do that, but that is a new requirement. That being said, I don't think that that is going to require a crazy involved process. I think you can use common sense. So if this person has owned their unit for 5 years and they've always used this email address to communicate with you and they email you a proxy, I think verifying that it's the correct email address for the right owner is probably sufficient, especially if you document that that step was taken to verify the validity of the proxy. So that's another change that I know took effect this year. And again, will not apply to everybody until 2028, but applies to Kiowa communities now. I think that is all that we have. I don't see any additional questions in the chat. And also it's 10:58, so we're coming up against the hour anyways. So I think we're going to say goodbye at that. And we hope to see some of you guys at CA Day on Saturday. And we'll see the rest of you hopefully back here next week. Thanks, everybody.